Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Today, we are pre-recording this episode. So actually, as I'm speaking with you, it is not Friday, it's Monday. And Mindy was so kind as to come on a little bit early and pre-record this. We don't have the opportunity to interact with a live speaker today, but if you have questions, please post them anyways in the comments section below, and we'll circle back and see if we can address those for you at a later time. As always, you can reach out to Mindy or any of us here at KTI to ask questions and whatnot anyways. But I was able to leave a little bit early for my Memorial Day weekend plans. So I took the opportunity and am, as you're watching this, out and about. So despite that, episodes are released each week following the live broadcast, as we usually have it live. So please be sure to hit the subscribe button and the alerts icon so that you don't miss an episode, whether we're doing it live, whether we're doing it pre-recorded, or whether we have a replay. You always want to know what's going on with the podcast. So today, as I mentioned, we have Mindy Bish with us to talk about what to do when liability is admitted. Now, some of you might say, what? That never happens in my cases. In Washington, it always happens in our cases. Even in tractor trailer cases, it's always admitted liability so that they can keep out all of the facts about what they did wrong and try to just make it an events case about damages only. Now, of course, we all know Mindy, Papa Don's right-hand woman and lawyer extraordinaire. She's also a fantastic KTI teacher, which incidentally is her background. I don't even know if everybody knows that. But Mindy, no matter when defense admits liability, whether it's out the gate, as we often see over here, or whether it's the day before trial, as I know a lot of people often see, please share with us your insight into how we can still use EDGE principles to get justice for our clients.
All right. Well, in some of what I'm going to talk about applies to other states other than Washington, because I was very sad to learn that in Washington state, you don't have the ability to seek punitive damages, which is really something you guys have to get changed in your legislature. And so what we have been doing during the pandemic with our beach people is really drilling down hard on the issue of admitted liability. Because what I hear a lot of is, yes, I took Greg Luther's black letter law class. Yes, I had my black letter law brief, but the judge didn't read it, didn't care, and wouldn't let me get any of it in as it was. And so, you know, part of what Mr. Keenan talks about is having lots of arrows available to you, lots of different avenues. You know, we talk about being the woodpecker. So you want to have all the different ways that you can go at it. And so one of the things that we developed is, you know, in most states, the defendants wait to admit liability till maybe a month before trial. It may be on the morning of trial. They never admit from the get-go. And so what we have to do as lawyers is the very first thing we have to do when the case comes across your desk. We're talking about on day one, before you ever file the complaint, is to take a look at your case and analyze it and really designate with what percentage of certainty do I believe that the defendants in this case are going to accept liability. They'll never call it responsibility, but they will call it liability. You know, and the truth of the matter is, as lawyers, even new lawyers, we all know when the facts for them are so bad that they can't allow those facts to go in front of a jury, or when they are so clear, they are going to admit liability because what they're going to do is try to curry favor when it comes to damages. This is not shocking. And if on this podcast there are defense attorneys out there watching it, I am sure I am not saying something so earth-shattering that they think I'm giving away, some deep secret. We all know it. Where we as plaintiff attorneys go wrong is we fail to think about that from the very instant we get the case. We think admitted liability, either we think we're going to settle the case, no problem, they're going to offer us, they're going to drive their truckload with money and dump it at our feet, so we don't need to worry about it because they have to. Or we just don't, we figure we'll worry about it later. And that is where we go wrong. We have to think about it at the beginning. And then what we have to think about is, what are the facts that the defense is afraid of? What is it that is going to drive them to admit liability in order for the jury to avoid hearing? 99% of the time, there are some facts there that they don't want the jury to hear. Whether it's somebody fell asleep, somebody is under the influence of alcohol, there's something in there they don't want them to hear. And so you have to analyze that and set it aside, almost write it out on a piece of paper. As much as you look at the defense strengths, you have to ask yourself, what are the facts that they're going to do anything they can to keep out, including admit responsibility? In fact, we have a premise case, believe it or not, that there are some really bad facts on the part of the defendant, and I expect them to accept responsibility. It's a brain injury case and just fight on the issue of whether she had a brain injury. Yeah, we did it. Yeah, it happened, but her damages are being exaggerated because that's what they do. So step number one, analyze your case from the day it walks in the door and assign it a percentage that you know the defense is going to likely admit facts or admit responsibility to avoid the facts. Step two, identify the facts that they're afraid of that's driving them towards accepting responsibility. Now what do? Step three, figure out how you're going to keep those facts in, whether they accept responsibility or not. Now, how do you do that? Well, number one is you figure out whether or not you can use those facts to support a punitive damage claim. That's the easiest way, unless, of course, you're in the state of Washington where you have no punitive damages. So that's never a consideration for you guys. But in other states where you do have punitive damages, you don't assume, go to the law books and figure out, can I get punitive damages, not only against the driver, but for example, in a tractor trailer case, can I thread the punitive damages to the company that hired him? How far up the scale can I get the ratification? What facts do I have to prove to get the punitive damages in? That's a case that we had, where we had a driver that basically fell asleep, who had been taking prescription drugs, but they were opiates. And what I did was I looked up the law in that specific state. I knew I could get punitive damages against the driver, but I don't want them against the driver. I wanted it against the people who hired him. So I did my research and I had a memo that said what I needed to prove to get it against the company. So that's number one. And if you can get there, then you don't need to do anything further because you've got it. And you've got to know that you've got it, so that while you're doing all of your depot hits, what you're doing is you're showing the defendant you can't admit responsibility here, because if you do, I'm going to win on punitives, and you're going to have to fight this battle anyways, because it's all going to come in. And that's exactly what I did. So I had my memo. I knew that what my elements of punitive damages were. I converted those elements into my depot hit list. I didn't ask your, like, how far were you when you fell asleep and I didn't care about any of it. The purpose of my depots were one thing and one thing only: to prove my punitive damage case. That was it. I took 6 depots in one day. It took me about 8 hours because I didn't waste time. I knew what I was there to get, and I stayed with what I needed to get. And that was proof that I could use when they filed their motion for summary judgment on punitive damages, I would have enough evidence to oppose it and get it to a jury. So that was a well thought out plan before the depots that I started from the beginning. All right. So that's one way that you do it. The second way to do it, let's say if you're in the state of Washington and you have no punitive damages, is you have to make it part of your damage case. And you have to make it part of your damage case from the very beginning. It can't be part of your damage case 3 weeks before trial. Now, what do I mean by that? So what I'm talking about is making sure treating physicians have all the evidence. For example, when we take defense core, which is, what we call the other side's experts, when we take their depositions and we ask for a complete copy of their files, what do we find in those files? Routinely, what do we find in their files? It's a defense orthopedic doctor. We find traffic collision reports. They always get them. We find photographs of the damage to all of the vehicles that were involved. Always.
It's true. And it's like, why? Because you're a doctor. Why are you looking at these things? What does it have to do with anything that you're here to opine on? Why?
Except, Jenna, if what you're trying to do is to get them in, if you think about it ahead of time, you, instead of asking, why do you have them, and try to show how ridiculous it is that they have them, you're going to go in and talk about how important it was to their opinion that they have them. Because that's the road way to get them in front of the jury. The pieces of evidence that show how the crash occurred, that talk about the movement, all the things the defense wants to keep out, you can get in by turning it around and making this doctor the advocate for why it's so important that a doctor understand this information. And by the way, send them to your own doctors. Send your doctors the traffic collision report. Send your doctors your client's deposition to read when she talks about how the crash occurred. Send her the discovery responses where she talks about how the crash occurs. The defense court gets those, send them to your own doctor. If you have videotape, send them to your doctor. Have a discussion. Was anything in here important in your understanding of how the crash occurred, and to understand the injuries that were presented to you on that date? And I'm not talking about send it, after they're done treating. I'm talking about sending it on the day they start to treat. We fail to do these things And we leave ourselves open to then allowing all this evidence to be excluded on relevancy grounds because we don't build the relevance of what it is that we need through our doctors and their doctors. We go in short-sighted, right? We're going to go in and show you're a defense whore because you have a traffic collision report and you have photos of the vehicle, instead of thinking, well, wait a minute, I want these in. So I'm going to go in and get you to talk about why they were so important rather than why do you need them? Mm-hmm. Because I want to be able to show them to a jury, rather than that knee-jerk response to impeach. I'm going to use you. Then when they object, I'm going to go, wait a minute, Your Honor. Even the defense doctor said it formed the basis of his opinion. Therefore, it is admissible. My doctor said it. His doctor agreed. Now, under the law, that means it's in. And so this is what I'm talking about, thinking outside the box, but you can only do that if you start to think early. So I'm going to share my screen for a minute because I want to show you a couple of examples. I know that you had Clayton on here regarding his opening and regarding his verdict on the case in Florida.
Yes.
And I think Clayton told you I wrote his opening for him. I think I've been told that he told you, but I did. I wrote that opening and I know that he showed it to you, but I wanted to, that was a case where we really worked on knowing that you had to get this videotape in. So part of what we did is we did this MOI and an MOE. For those of you who are unfamiliar with that, that's showing how the mechanism of the event, how the crash occurred, and it also showed how the injury occurred. And so what we had, let's do the slideshow, and let's just play from this current slide. So this was, you watch the red ball, the little box. This was an admitted liability case, right? We knew this video had to come in. We knew it from the very beginning of this case. Without this video, this case is, I mean, it's a brain injury case. Without the video, there's no system failure. And this is just an event case. Luckily, maybe gets $100,000 in a verdict. Mm-hmm. So we knew getting this done was critical. The defense admitted liability, so they never told the jury exactly what caused their driver to careen into the pedestrians. We focus grouped it. We knew that they thought that lack of sleep was like drunk driving. They were excited about it. Mm-hmm. What the defense never understood was by showing the video without telling anybody why he did it, they heard college student, spring break, and saw the video. And when you asked and said to them, now you're the jury, you're never going to be told why it happened. I want you to write down on a piece of paper why you think it happened. They all wrote loaded, drunk, loaded, drunk. Mm-hmm, mm-hmm. So that gave the jury the idea that the kid was drunk. We always knew they would admit liability, But we knew that if they saw the video without any explanation, they would think drunk. And if they thought drunk, they would be 9s across the board, 9s and 10s. So how did we get the video in an admitted liability case? We gave the video to every treating doctor related to her brain injury. And every treating doctor found some part of that video that helped them to explain how they came to their conclusion to a medical certainty that Andrea Reyes had a brain injury. And it was in their file, and it was in their deposition, and it was in their reports when reports had to be exchanged. And it was given to the defense attorney, not when it had to, but early on. In fact, this entire MOI, MOE that you saw was turned over early. Not a surprise, not a let me just show you how wonderful my artwork is a week before trial when I have to. It was given up months and months before trial. It was used in every single deposition, every time it was pulled out, over and over and over again. The days of surprise attack are done. You bring out something sophisticated and perfect, and you show it to the defense a week before trial, they make a motion to the court that says, this is the first time I've ever seen it. My experts have never seen it before. Wah, 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 wah. And you know what happens to your beautiful piece of demonstrative evidence? 99.9%. It just gets kicked. You can't use it in opening. Maybe you can use it later on down the road after they've had a chance to see it, but not using it in opening means you've lost all of the perfect attempt you had to be able to use it. So this was an instance where an MOI and MOE was created months and months before trial and used in every deposition. So what does that mean to you? It means before you file your lawsuit, you should have your MOI and your MOE done. Your demonstrative evidence. In fact, on the Keenan checklist, which Jenna can tell you, it says have your demonstrative evidence almost done before you ever file a lawsuit. And the purpose of that is to use it in every depo you take. It's not to hide it. It's to use it. It is powerful. And it is one of the ways you protect the evidence so that you make sure no matter what they do, it gets in and it's legitimate. You're not hiding anything. It has a purpose. The doctors will use it. So send everything to your doctors. When you do this kind of demonstrative, send it to the doctors. Everything becomes part of their file. Everything becomes part of the defense file. I don't care if they have it a year and a half early. What do I care? What are they going to do? It just tells them I'm ready for trial, and it's a year and a half before trial. So these are the ways, in addition to black letter law. I am in no way saying you don't do. You do black letter law. You do the briefs under black letter law. You do all the things that, Greg has taught you at the college under black letter law. But you do these things too in order to protect your evidence. None of them are trickery. They are legitimate. The defense knows how to use them. We just get too carried away with too many cases, and we fail to do it and to do it correctly. Now, some of the other things you can do is you can use timelines. Jenna and Young G, in their case, had a mechanism of injury on a foot case that threw everyone over the top. that showed the intricacies of a foot injury case that really scared the bejesus out of the defense. So even if it allowed them to have a little bit of show and tell about how the crash occurred to explain the injury. And so that worked for them. I would put in slides all of how the crash occurred, let the judge decide it's too much and take out. Don't edit it yourself, because then you have nothing to bargain with. But, these are the tried and true ways. The third thing is hit lists. And that is really incorporating what I've talked about in number 2. In number 2, we talked about what I like to call, prepare and protect. You are preparing, your memos, you are preparing for the defense, specifically, admitting liability. You're protecting the record of the evidence that you need to get in, whether it's through punitive damages, whether it's through giving the doctor the information and making sure that he's ready for his deposition. And then it's using the information in your hit list. It is thinking about the depots that you take. And we talked about that. Thinking about the questions that you ask. Don't, too many times people go into an expert depot and the first question they ask is, doctor, you realize you're under oath, or something else to make the doctor nice and comfy in his chair. Let me just get you really comfortable in that seat, doctor, and ask you the same questions thousands of other lawyers have asked you beforehand. We don't do that. I don't ask doctors about their CVs. I don't ask them where they went to school. I don't ask them, about what they were, if I ask them, is this what they reviewed? It's because I know they're missing something and I want to lock them in that this is what they reviewed. It's a question with a purpose. It is really asking my best question first and my second best question last. It is really working my hits. It's thinking about, why am I asking the doctor this question? What do I need from him? We take depots at the Keenan Law Firm and at KTI, and it's what we teach you. We take depots to prove our case. Maybe you look to impeach theirs, but too many times we're going in to try to humiliate a doctor, and the truth of the matter is, if we were just smarter, that doctor would prove our case for us instead. And we're just not smart enough to really sit back and think. And so we need that think time. And once you do these hit lists, I ask these questions, if they are my case winning hits, I ask them of everyone, including doctors, even if they're not particularly within the doctor's area of expertise. In the case in which I had someone driving who had taken a prescription opiate, my question is, when is it safe to allow a tractor trailer driver to take opiates and drive a tractor trailer? That was the question. Simple question. When I asked it of the 30B6s and the managers, everyone kept saying, I don't know. I don't know. I don't know. Well, I asked it of all the doctors too. I asked it of everyone. I did. If it's a good question for one, it's a good question to ask everyone. Everyone, and the funny part is the defense kept asking me, when are you going to ask a question that matters?
Yeah, I love when they do that.
Because they don't even understand. Well, I think they do understand when they look at it later on that all these people said, I don't know. Mm-hmm. Really? Because Bubba knows. Mm-hmm. And it was one of those questions on hit lists that it didn't matter what they said, they were dead in the water. Now, because I believe credit is due where it is earned. That was not my question. I worked 2 months on putting hits together, and Mr. Keenan did what he normally does. We went through a VC and I read him my questions, and some of them he liked. They were good, but I got this, well, let me make a small suggestion to you on the first one. What if you just ask it this way? And he gave me that question. Because that's how it works with him. Like he can just sit back and you always know when he goes, let me just make a small suggestion. He's about to come out with the question, the one that you go, shit, I've been working on this for months and I didn't think about it. So giving credit where credit is due, that was Mr. Keenan's question. I wish I could claim it as my own, although I did fire it off and I fired it well. But that's all part of it. So, and then, there's always the fourth. And the fourth is, if you can't get punitives and there is no way to hold it all in, then you've got to look at it. If you can't figure out how to make this, if they make it a damage case and you've got a judge that's going to strip you of every ability you have to make it a system failure case, then you really got to look at settling, because you're not going to win that one. You're not going to win that one. If that case becomes about your client's injuries and nothing more, it is an event case.
Yep.
That's where we get the low verdicts. And it's recognizing that too. Recognizing when it's time to resolve and move on. So anyways, that's what I came to talk about. I am available, at mbish@keenanlawfirm.com. I'm available. I am the managing partner of the Keenan Law Firm. I always laugh. I tell people I moved to Florida. I'm still with Bish and Cutting in LA. I'm the managing partner for Keenan Law Firm. This is what I call retirement, which is really funny to everybody else, but, but I'm up here in Florida. I run the tractor trailer group, I run the premise group, and I run the new employment group. I have help from Melinda Young. I could not possibly do this all by myself. So I want to, give her credit for really being there. And I always tell people, look, she can keep up with me. So we're good. We're doing live workshops down at the beach. It's summertime, which is always my favorite time. Mm-hmm. So that's what I have for you. I do answer questions via email. Feel free to send them to me. So Jenna.
I can attest to that, folks. It is true. Mindy will always answer a question if you send it in. And it's always thorough and enlightening. And just kind of to highlight that whole thing, Mindy, you mentioned that in collaboration with another lawyer, albeit it was Papa Don, but in collaboration with another lawyer, you saw an opportunity to improve your questions. And we talk a lot on here about how practicing in a vacuum is not the edge way, and to reach out, to ask questions, to role play. I mean, I even find Young G and I have two totally different brains, completely different. We are the same person, but somehow our brains work totally differently. And so when we sit down and role play, it's like, oh man, and we're in the same firm. So even bringing in somebody else, maybe who's edge from a different, area, a different colleague from a different part of the country or whatever, all kinds of ideas fly, and it just makes things so much better. So folks, just feel free to reach out to anybody if you have questions about that sort of thing. Another thing I wanted to highlight, Mindy, is your discussion about disclosing things early on. A lot of times people are afraid to disclose either demonstratives or other visuals or whatever, because they're afraid that the defense is either going to co-opt it or come up with their own really good idea, or, I don't know. I don't want them to know about it because then I'm giving it up. What say you to that?
If it's good and if it's spot on, there's nothing they can do about it. And remember, what these demonstratives we're talking about are the things that the doctors have to see and the things that have to be used for you to keep the evidence in that you need. And so by not doing it, you run the risk of the judge disallowing evidence that you have to prove your system failure, which then means your case is over. So, and, I have never worried about the defense co-opting it because, if I've done my job well, and I have focus grouped my demonstratives well before I send it over to them, what are they going to do? Now, if you've lied in your demonstrative, if you have not been honest, if it is not accurate, they have a lot to do and you have a lot to worry about. But if it is spot on accurate, there's nothing they can do. And it also scares them to know that you're that ready.
Good point. How do you know if it's good and accurate and it's ready to be released over there to the other side?
Well, you focus group it. Okay. And if you go back to during the pandemic, we did a focus group where we invited people. We did various focus groups and everyone came in. And I think I focus grouped your MOE, Jenna, I think, during that one, or it might have been, no, it was somebody else's. But basically what you do is you take your demonstrative evidence and it should speak for itself. So on an MOI and an MOE, the mechanism, the slide shows that we do. What we do is we click through them silently in front of a focus group. I just do one slide at a time. I count to 5 in between because I want to make sure that I go slow enough. And I go through it very slow, what seems like incredibly slowly. Then I go back and I do it a second time, a little faster, because a lot of times they'll pick up a second time what they didn't get the first time now that they understand what it all is. And then I ask them the 4 questions, who's responsible? What are you basing it on? And if the demonstrative is done well, they can answer all those questions just from the demonstrative. And then you go through and you ask them, what should stay in, what should come out, what didn't work for you, what did. Some of it you take with a grain of salt. Because you understand why some of it's there, some of it you don't, but you basically go through it. And if they can answer all the questions, if it, basically lights them on fire about your case, then it's good. And then you start to use it.
Oh, and I'm really glad that you talked also about just knowing when to call it a day. If you get through your preliminary motions in limine and whatnot, and the judge has kind of stripped you of everything, even though you set it up, even though you've got experts relying on it, even though you've done everything you can to get that liability or the system failure evidence in, if the judge strips you of it, just don't forget that there's still that opportunity to resolve it and do justice for your client that way. Unless there's a zero offer on the table, then what do you do?
Well, I mean, the idea is, you can look at it to see whether it's a case you intend to appeal. But sometimes what I have been guilty of in my career is putting blinders on and going in and fighting every battle. Not every battle needs to be fought. And I think that that's come with age. But a lot of times I don't have to wait for the judge to strip it all. It's a feeling that it's, things are not rolling into place. I can't do punitive damages. The doctors are bucking on the idea that this is helping them in concluding on the damages. Things are just not, every idea I have of getting it in is failing. There's things like that, because if I wait for motion in limines, then my poker hand is empty and the defense knows it. So you have to also know when to time your mediation or your settlement before you have an empty poker hand. Basically, you kind of have to know that this is going south, and they may not know it, but I do, you know what I mean? And go get it done.
Yeah. Yeah. And I think I agree with you that it takes some time and doing and learning from just kind of going forward with the blinders on and getting kicked in the face and then going back and doing your memo about how the case went and looking at the next case and saying, oh gosh, I've seen these signs before. I've blown past these red flags in the past and it did not go well. Is this the same situation or is there something distinct about it that I should, or as possibility of moving on? It's so, yeah. And in fact, I just had a meeting this morning with Jason Ehrlich and David Wiley about the employment seminar coming up. And I said, I got to have better talks with my clients about appeals and what happens when things don't go right, because this is still very much a learning process for me where I'm like, okay, I want to get into the courtroom and just tear everybody apart. And not everyone's always with me, through that journey. So yeah, that's a learning experience for sure.
Yeah. Well, what we're really talking about in admitted liability cases is keeping the system failure alive. Mm-hmm. That's really what we're talking about. So, the question is, if you've identified the system failure from the beginning and you continue to track it through your, do I have the system failure here? Do I have the system failure here? Is my system failure still alive? Do I still have evidence, admissible evidence of my system failure? And you remember that this is not an event case. It's a system failure case. Have they stripped me of my system failure?
Yep. And then don't be shy about it either. You have to admit to yourself, right? I think that's the biggest thing I've learned is I shouldn't say shy about it, but it's kind of an ego thing at a certain point. And that's never a good thing, right? We don't want to make emotional decisions. We want the jury to make emotional decisions. We need to make good decisions based on kind of our learning and that sort of thing. Set the ego aside. Yeah.
Well, the hardest part, when I first came to the edge with Mr. Keenan, I always tell people the very first trial that I tried after being in the edge, I tried in Bakersfield and I got a verdict. And then we went on a run where like the next 6 trials were all 7-figure verdicts. And the hardest part was, and then we came up against the next one. And I had this feeling like I can fix anything. I understand how the edge works and I can fix anything. And then we had a run of 3 defense verdicts, right? Because Keenan always says it, you can't, you just can't. I know he has a saying for it that I'm not remembering because it's a Southern set, but I've had to remember that you can't. And so, but there are, I just hear so much, the defense is admitting liability, woe is me. Mm-hmm, mm-hmm. And the problem is by the time if you haven't done anything about that, then woe is you.
Yeah, woe is you, yes.
You know what I mean? If you haven't planned for that already, you're screwed. You are at the whim of a good judge with a black letter law, but if you have planned for it since and that's what we really strive to do. And we had success with the Washington case, and we had success with Clayton's case. And, we have had success by planning. We wouldn't be here talking about it if we didn't. We don't, it's not just one case. We have had multiple cases in which we have planned early, looked at what the facts were, knew that they may admit liability, looked at punitive damages, and had a backup plan if that failed.
Mm-hmm. Yep. And for those of us in Washington, this is even more important, I think, to remember, look at it right away and plan. Because anybody can correct me if I'm wrong, type it out in the comment section that this is only happening to me, but I know it's not. But in the answer, a lot of times, anything with a car involved, tractor trailer, car crash, anything, because the defense, we have terrible law over here on corporate negligence as far as the being able to hold a corporate defendant liable individually apart from like the vicarious liability. It's terrible. And so they're happy to take vicarious liability. They don't care because it's not ever holding them accountable. They will never change their ways. They don't have to. But this talk today, Mindy, is so important for us because we do have the opportunity to plan on how to get that system failure in despite that admission of liability. I think it's a little bit trickier for folks in other jurisdictions who have to remember about liability before it's admitted. And that's really cool. That's a piece of advice that you're bringing today, is to like think about it. That's got to be on your list, on your to-do list. Think about liability. Have the contingency plan. How are you going to do discovery if they admit it right away? How are you going to do it if they don't? And maybe they admit it the night before or the morning of. And how are you going to handle all those things? And how are you going to be prepared?
Well, it's asking your client. It really does go back to, how did your client feel when she first saw the vehicle in front of her? Did she have a child in the car? It is really trying to get to the PTSD, the emotional distress, the ongoing issues that they're having. David Crump and Ed Harper are in Washington. They kept in some of their bad, not all of them, but they kept in some of their bad facts against the state of Washington, even when the state of Washington came in at a later date and admitted responsibility, because they had so interwoven them into the damage portion that they were coming in.
Absolutely. And if you think about pedestrian cases, any case, being hit by a car and knowing it's some like big bad corporation behind it, and they're going to get away with it, all of that does go into emotional distress damages. But another good point too that you made, Mindy, is if you're having to pull teeth with your treating doctors to talk about it, they're not really getting it. They don't really understand it. Pulling teeth with the treaters is a big red flag. They're not really getting there if they're not willing to make that connection. And of course, you don't want to manipulate them or force them to say something that they don't really believe. And so you're just stuck with what you're stuck with, right? And then right. You make your decision. All right.
Right.
And you mentioned earlier, Mindy, before we started, that you're going to come on and join us again and talk a little bit more about hit lists with a panel. Will you give us a tiny sneak peek preview of that as we wrap up this afternoon?
Sure. I've been teaching hit lists. I'm the dean of the hit list college at KTI, and I teach most of the referring attorneys hit list training. So like we're going to do live hit list training with the referring attorneys in the employment group in the middle of June up here at the beach. So lately we have had some real success stories of attorneys who have learned hit lists both at the beach and at KTI. Concrete before and afters, where I was before, what happened afterwards, who not only did the hit list training, but put it in a PowerPoint. One of the attorneys is going to talk about after hit list training, basically they tendered the policy after a depo. And what we're going to do is we're going to bring on these attorneys, people just like everyone else out there, in a roundtable discussion with all kinds of different cases to talk to you about how hit list training has changed the way they approach their cases, with specific concrete examples of how hit list training changed the tide of a specific case. So I'm hoping to bring on 3 or 4 different attorneys. One of them is an attorney less than 2 years who took hit list training and said it was just light bulb moments all over the place. So I just think sometimes, I can talk about how important hit lists are, but when you get to hear it from, other attorneys, it's much more impactful. So we're going to set that up for some time during the summer. I'm going to bring on a bunch of attorneys to talk to you about their experience, from attorneys with little to no experience doing depots all the way to, attorneys who've been doing depots for a while and had to change how they did them to be able to talk to you.
All right, awesome. And as Mindy said, we don't have it scheduled yet, but please keep your eye out for that episode because it's going to be a good one. It's always fun to hear concrete examples of how, an edge course or edge concept has changed somebody's career. And I'm excited to hear from people who have been doing it for a long time and to see from many in our audience who are watching that you can change your ways. It's difficult, of course, as it is with any habit you've formed, but you can do it. And then to hear how exciting it is for younger lawyers to start right out off the bat with such an incredible skill. That's so cool. All right. Thank you, Mindy. Thank you for offering to pre-record this with me and indulge my extended weekend plans. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you like today's episode, please hit that thumbs up button, subscribe, sign up for alerts so you don't miss an episode. We have an absolutely action-packed June for everyone. We have live, I think I'm looking at the schedule. We have live people every single week, except maybe one. And we are going to have a very interesting segment of guests where we talk about some things that will enrich our lives that are not exactly practice-based. So that will be really interesting. Some plant-based stuff, I don't even remember everything exactly, but we have a bunch of really interesting nutrition. It'll be really, really fun. Next week, we're going to kick June off with Elizabeth Lyric, who was with us before to talk about witness prep. She's going to join us again to talk about taking witness prep to the next level. That will be a super exciting episode. So I look forward to seeing you live on June 2nd. Have a wonderful Memorial Day weekend, and I will see you guys next time.